case
hold on.
by
Michael,
Myers
hold on.
versus Nebraska.
Could we mute my client, please?
All right, this is case D23R. It's a sealed matter in the matter of the parental rights of appearances for the record, please, beginning with petitioner's counsel.
Good morning, Your Honor. Jack Fleeman, bar number 10584, on behalf of the petitioner who is present via Blue Jean. She lives in Oregon.
Good morning, counsel.
Good morning, Your Honor. Valerie Fuji, bar number 5955, on behalf of the respondent, Michael McDonald, who is also present via Blue Jean. Michael, if you could turn your video on, please.
All right, you can be seated, counsel. All right, we're on calendar today on two matters. One is the petitioner's motion for a summary judgment on the issue of jurisdiction, and the other is the respondent's motion, and since filed amended motion to continue the trial date. Let's talk about the trial date first. Let me begin by telling you the court needs to do a little bit of trial calendaring maintenance here. Unfortunately, I'm double booked on the day that we're set. When I inherited this calendar, they had dropped a bunch of cases into it from other departments, and so I have cases all over the place. So I do need to do a little bit of maintenance, and it will result in us pushing the trial back probably to the beginning of the year. But I do want to have a discussion with you both about this evaluation, because, I mean, has any progress been made, Ms. Fuji? I mean, has anyone even an evaluator even been selected? Because I know what's going on in this community as far as getting an evaluator pinned down and get them available to do work is challenging right now.
In response to your question, Judge, it has been hard. But I will say the county's been gracious, understands the gravity of this proceeding being a termination. And I have an appointment on Thursday at 1:30. That's the 28th of September with Dana Anderson. She is a California psychologist recommended by. So at least I've got potential. I also reached out to DFS Clinical. They do evaluations for 432B cases and delinquency cases. She gave me a list of providers that are not Clark County. They're not employed by DFS Clinical, but they do have the credentials that's necessary in compliance with the custody orders to do the evaluation. And I will reach out to them. I think I'm going to have to call. I was sending this blanket email, Judge, like, hey, let me tell you a little bit about the case. And then I think what happens is if Mr. Fleeman's office gets a hold of them, you know, unfortunately, there's a tormented history. I see it as a simpler case, I think, but I think it's very important that they get their opportunity to unload the history, both criminal and civilly, on this psychological assessor, so we can get a full evaluation. But truly, it's necessary because we were asking for cards and letters, some sort of contact, and that appears to be barred by the custody court decision until this evaluation's done.
Yeah, and that condition of that order was put in place a long time ago, right? I mean,
yeah, it's so weird. So in the D15, the order from July 3rd, 2019 and December 7th, 2020, my client was incarcerated at the time. First, it said we needed someone with a PSY or PhD to see if he's a danger or harm to the children. Then the subsequent order in December 7th said it has to be either Berquist or Holland, which I thought, wow, okay. So I reached out. I got a hold of Berquist. I got a hold of Holland. Both declined to accept the appointment. So then I just looked for anybody with a PSY or PhD. At that point, Mr. Fleeman got in touch with me. He had been involved since the inception of the custody case, I believe, and we formulated a stipulation and order of what the scope of this assessor would be. That was filed in this case on July 25th, 2023, and now we just need a mental health evaluation of respondent for the sole purpose of assisting the court in determining if there's any physical, emotional, or mental risk that respondent presents to the children. It's not to determine whether or not his rights should be terminated.
I saw that, Ms. Fuji. I mean, you know, here's the issue I'm having in several cases now, is that the parties agree in principle to have this done, or the court sets it as a condition, and then it's becoming like near impossible to get them actually done, right? And it's stalling these cases. And I mean, I do see, and I've saw the stipulation, and I do see how that is beneficial. Could be beneficial to the court to have some information and some input regarding the risk factors, right? I mean, we're not getting an opinion regarding best interest. We're not getting an opinion regarding termination. But if I'm getting some information and some input regarding, you know, psychological, emotional, mental type risk factors, then that would be very beneficial. So I need to move this trial regardless of the request and that came in. And so my question really is, if I move it to sometime in late January or early February, is that even a realistic date? That's what I'm concerned about. Sure. And I know
I'm hoping, Judge.
Hold on, Ms. Fuji. And I know your client is anxious and wants to have this matter heard. I understand that. I'm trying to, you know, obviously have to balance. You know, you guys, we did set in motion this process of getting the evaluation. So I don't want to short circuit it or cut it off right midstream.
Can I bring 3 things up, please?
Hold on, Michael. We'll get an opportunity to talk.
Sure.
The 2 evals done and jurisdiction and.
Sir,
Michael, we'll get an opportunity to talk.
Sure. So I don't have a problem with the continuance of the trial. I think I said that in the opposition. In terms of the evaluation, it's not something from our point of view that we think must be done, but we do agree that it can be done, and that in the custody case, which is closed, it is a requirement. Our issue in this case, and I would like to make a little bit of a record, is Ms. Fuji said that she believes that I'm contacting these people to give them a history of the case, which hasn't happened. I know the court doesn't really care too much about that, but for the record, I haven't contacted anyone to give them the history of the case. Ms. Holland, or Dr. Holland, did take the case, and then she later said, no, I don't want it. I don't know what happened there. It is required by the custody case that the evaluation, that my client is involved and able to give information, and that the evaluator has access to the record. So that was part of what we put in the stipulation in order. So right now I understand the court's quandary of when do we put this, because I don't know if January or February is going to be, that's probably too soon, because we're coming up on winter fairly soon. These take, you know, at least 90 days or so sometimes.
That's what I'm concerned about. And
I gave the California Dana Anderson name to Ms. Fuji a couple months ago, I think. And this is the first time I'm hearing that it's being looked into. I think she already told my client that she can do the evaluation, so I don't think it'll be a problem, but I don't know how this court is going to set a trial date based on that. I think I don't know how we set a date today, honestly, and I think February is probably too soon.
Yeah, so you're thinking more of a status check to make sure that we are at least working towards a conclusion of that evaluation before we set a trial date. And listen, my trial date, I mean, beginning January on is wide open. So if we set a status check at the beginning of the year, and we learn at that point that you know, we're making good progress, or it's either concluded or it's about to conclude, then I'm sure we can get a trial date on in the 60 days after that. Okay. So I understand. Okay, so that's your client's position. So did you hear that, Ms. Fuji? So Mr. Fleeman is sort of saying is, let's just set a status check at the beginning of the year. But I mean, your client, you need to be diligent in moving forward with this, because because if we come in the beginning of January and there's no real progress having been made for whatever reason, I mean, at some point we do have to, like, you know, move on, right? I mean, that's correct.
So it's unfortunate, but the way it was written was he cannot even send a card or a letter or a birthday card until this assessment is done, essentially terminating his parental rights. Yeah. So he has been denied all contact. Generally, I would have been requesting reunification therapy. I would have been, because of his absence, I would have been requesting contact, phone, video, but none of that can be achieved till because of the orders in the custody case. So
we'll
the
talk about that
deadline for the expert is October 16th, and we're going to miss that deadline, obviously. We are at the mercy. I tried somebody in state, and then I tried somebody that would be approved by the county, so it wouldn't cost.
I understand the challenge that you're facing, and I get that. So we're going to set a status check at the beginning of January.
Alex, can you bring up that there was an eval done in April? Like there was a brief focus.
Yes, Michael, I will do that.
So I did my due
Michael.
diligence
Just
in
hold
trying
on,
to
hold
fulfill
on.
requirements.
Let me do it.
This
I think the
is
judge
denial of parental
understands.
rights
Hold on,
by
Michael,
Myers
hold on.
versus Nebraska.
Could we mute my client, please? So, Your Honor, there was an assessment done by Phil Colosimo the day he got out of, incarceration. Then he was on P&P, parole and probation, and he was honorably discharged on April 16th, I think, of 2022. At that time, he underwent a psychological assessment with Phil Colosimo.
Hold on, Ms. Fuji. I don't understand. And just to keep, and you'll advise your client after today that what we're here on today is a petition to terminate his parental rights. I mean, this is not, we're not on calendar day on the custody case.
Correct.
Divorce action. Do we have a date in the second week of January?
Yes. Status check January 9th at 10 a.m.
Does that work for you, Mr. Fleeman? Ms. Fuji, does that date work for you?
Yes, Your Honor.
What'd you say, January 10th?
Can you bring up there's also a court date? Oregon.
Michael, that's a different motion. We'll argue next.
Yes.
All right, so we'll have the status check then. We'll check in with you at that time, Ms. Fuji, to see, hopefully we'll be able to set a trial date at that time. The trial date that's currently set for December 18th is vacated, as well as the calendar call set for December 5th. Okay, let's turn to the motion for summary judgment.
Can we get a new scheduling order, Judge, too? Well, I guess we can't until we come back on the status, can we?
Yeah, I mean, essentially the discovery dates have all been extended by virtue of
Yeah, and
this.
I will let the court know that we have exchanged written discovery and we've also deposed both parties.
Okay. All right. Turning to the motion for summary judgment, Mr. Fleeman.
Yes, Your Honor. As Ms. Fuji mentioned, we've conducted discovery. It's still ongoing. We've both deposed each other's client. The issue is that even at the deposition, and Mr. McDonald is asserting that this court doesn't have jurisdiction over him, that there's no custody jurisdiction. The fact is that this case was filed in January. He was served February 2nd. He then relocated, he says, to Arizona in mid-April. The date I think he has now is April 18th, the most recent discovery that I've seen. His position is, since I've moved to Arizona, this court no longer has jurisdiction. Our position is, it's at the time of the commencement of the action. It doesn't, that's under the UCCJA, but even a practical matter, if parties could just leave the state and then the court loses jurisdiction, it would be mayhem. He has filed in the state of Oregon previously. He filed the wrong order. He filed an old order. That case was dismissed. Now that we filed for a summary judgment on the jurisdiction issue, and to be clear, I'm not saying that Nevada has made any determination that it's a more convenient form or any of that stuff. What I'm saying is this state has jurisdiction, has continuing exclusive jurisdiction over custody matters, which under the UCCJA, the termination case is a custody matter technically. So he has now filed again since we filed our motion for summary judgment in the state of Oregon.
Oh, he has filed in Oregon.
Yeah, he filed in Oregon. I think there is a hearing on the 4th, but I don't think it has anything to do with, I think it's his motion for reconsideration. I don't think it has anything to do with the substance of the case or the UCCJA or anything like that.
On the 4th of October.
I believe it's October.
To reconsider did they deny the registration of some sort? Is that what it
I believe
is?
they dismissed the case on the basis that he didn't register a proper order. But,
Okay.
I mean, he would know a little bit more about that. That's my understanding through my client.
Okay. Okay. All right.
Thank you, Your Honors. So I thought this issue might be a little bit.
I'll come back to you, Mr. Flynn. Go ahead, Ms. Fuji. I'm sorry. Go ahead.
No problem. Thank you, Your Honor. So Nevada obviously made the initial custody order pursuant to NRS 125A305. But this court has the jurisdiction to modify that under 125A325. Initially, I made the argument there was a simultaneous proceeding in Yamhill County under 125A355. And we had a kind of semi-UCCJEA discussion with Judge Moss and Judge Easterday from Yamhill County. And at that time, the court made some determinations. And I quoted this in my opposition because I think this is key. Under NRS 315 subsection 1B that a court of this state or a court of another state will lose that jurisdiction once they determine the child and the child's parents or any person acting as the parent do not presently reside in this state. So when we had this hearing on May 5th, 2023, Judge Moss made some interesting discussion. She allowed petitioner to do some discovery because they argued he purposely moved out of Nevada to lose jurisdiction. So the court allotted them the opportunity to conduct discovery on it, and they have. But my argument under the Carr case and under the Johnson case is once it's determined that the child and the child's parents no longer reside in Nevada, the district court does lose exclusive continuing jurisdiction. In addition, the extra argument is it's an inconvenient form pursuant to NRS 125A.365. And my extra argument is that there's a simultaneous proceeding. So what happened was Michael initially had filed a foreign judgment, used the wrong order, the last order from the court in Nevada he did not use. So since that time, he has refiled correctly the pleadings necessary in Oregon and has a hearing on October 4th, 2023 in Yamhill County. So here's what I can tell you. He provided a lease, he provided a driver's license, he provided a utility bill. These are part of our 16-2 production that will be exhibits before the court. He was deposed, as was Ms. deposed, and she has been with the children in the state of Oregon since December 2020. And what I foresee, what I hope to foresee, judges, if they're so worried about, respondent, if something happens visitation-wise, who would respond? Well, it would be the people in Oregon. It would be the school in Oregon. Visitation most likely would take place in Oregon. As much as I love to do this, I think Mr. Fleeman would agree. The best way to go forward would, and the children live in Oregon, and Michael lives in Arizona, would be to have Oregon have this case. There's already a proceeding that will move forward October 4th in Oregon, especially when this court makes the findings, and that's what I'm asking, and that no party presently resides in Nevada, and therefore Nevada's exclusive continuing jurisdiction ceases under the statute in the Carr case.
All right. Thank you, Ms. Fuji.
Your Honor, if I may, I don't know if you want to say something, but
No, go ahead.
in terms of the Carr case, I think that reliance on that case is misplaced. In that case, the father filed after he had moved. And the court made it clear. It said you filed 2 months after Kathleen was named the mom, and the children left Nevada. By that time, you were already living in Turkey. So nobody was in the state at the time of the filing, and that was the date that was important. In terms of where he lives, I think that is an evidentiary issue potentially because the discovery was not open to whether he purposely moved, it's whether he moved at all. And we've included a lot of exhibits that show he's in Nevada many, many times on a weekly basis. He's alleged to be living in a trailer just the other side of Hoover Dam, essentially. He produced a rental agreement with his mom. He testified that he doesn't actually pay anything, he kind of just does chores around them. But we have no bank statement showing any of that sort of thing.
So, let me stop you there because from the court's perspective, and I'll give you the benefit of my analysis because I'm not sure that it really matters all that much for these reasons. I think that the petitioner's correct that for purposes of determining continuing exclusive jurisdiction under the Friedman case, the analysis is assessed at the time that the petition or that the motion is filed. Here, the petition was filed back in January of 2023, the petition to terminate parental rights. And there's no dispute that at that time, the defendant was residing in Las Vegas. In fact, he makes that admission or that acknowledgement in his UCC JEA brief that I think he filed in April before that of 2023, before that last conference. It's right there in black and white, his acknowledgement that he was residing in Clark County. And so there's no doubt that when this petition was filed, this petition to terminate parental rights, that at least one party was residing in Nevada, and that Nevada had continuing exclusive jurisdiction. I don't know that we have a case in Nevada that says that the court then retains jurisdiction until the conclusion of that proceeding. I think that there are other jurisdictions that have said that. In other words, there's a case law in other jurisdictions that have confirmed that once that assessment is made, continuing exclusive jurisdiction is deemed established, that the jurisdiction retains its hold until the conclusion of that proceeding. So that if someone does move away during the proceeding, that's not necessarily going to divest the court of jurisdiction. So I'm satisfied that when this petition was filed, that Nevada had continuing exclusive jurisdiction. For me, and I'm not sure that his residence today matters all that much, at least not for that analysis. And we don't have a case in Nevada that defines what residence means, right? Does it just mean physical presence? Does it mean more than that, right? We don't know, and it sounds like there's some disputed issues there. I will tell you that the issue that I'm more struggling with is the one of the inconvenient form, and I think that the parties did sort of tee that up a little bit for Judge Moss back in May, but I think it all kind of fell flat because there was no proceeding in Oregon. Does that make sense? And there doesn't need to be a proceeding in Oregon for the court to find that it's an inconvenient form. But as I'm sitting here today, I can tell you what the court's concerns are. I mean, if the defendant has moved out of the state or crossed the state line by a few miles, and the plaintiff and the children have been in Oregon for now 3 years, going on 4, the state of Nevada is bearing the cost of the defendant's defense in this case, the therapist, and so forth. But here's my big concern, and Mr. Fleeman, this is to your client. If the defendant does register whatever the last custody order, the correct last custody order in Oregon, and if he files a motion to modify that order, right? I think that this court would now be in a position where if there's a new motion filed, right, the continuing exclusive jurisdiction analysis assessed today would be different, right? If he can persuade the court that he's residing out of state, right? Different today than it was in January when she filed her petition. I mean, potentially we could have cases going in 2 different states. That's what my concern is. We could potentially have the petition for to terminate parental rights here because it was filed in January, right? But a motion to modify custody may very well have to be filed in Oregon and can be filed in Oregon. Does that make sense? And so then it begs the question of, then I think we'll get to another UCCJA conference, and we get to the question of inconvenient form. I think what the court is struggling with is you guys have sort of taken opposite of what would be a normal position, right? I mean, typically I would foresee your client who's living in Oregon now demanding or arguing to me that Nevada is the inconvenient forum, right? And that she wants to litigate the case up in Oregon. But you guys have kind of switched roles in this case, which is complicating the analysis a little bit. Does that make sense? Because it's not following the lines of what logically I would think the parties would be advocating for.
Right, and in terms of that, partially the reasoning for that is because of the long tortured history of the case, plus all of the criminal cases, the incarceration, in prison in Nevada. There's a lot of information in Nevada. There's a lot of witnesses in Nevada, and especially in a termination case when it relates to fault, plus the best interest. These children, I think it was pretty much agreed that they weren't going to really be part of the process in this. So wanting to know about their schooling and things like that really doesn't carry much weight at all in the analysis of the termination case. It's really about Dad's fault and what he's done and what he continues to do in the state of Nevada. So our evidence regarding fault is all in the state of Nevada. There's nothing really going on in the state of Oregon.
So I'm with you though.
Except-
Sorry to interrupt,
Hold
Mr.
on,
Fleeman. I
hold on.
apologize.
But it just seems like I understand that, but it seems like what is Nevada's connection to the case, though, right? I mean, what is Nevada's interest in deciding this dispute. That's where I'm kind of struggling as well, though. If both of these parties have essentially, to some extent, moved on, certainly if mom and the children have moved on, like, what is Nevada's interest in refereeing this, right, and expending resources to do so, right? I mean, that's
Right, and
a
that's
concern
a little
for
bit of a separate
me.
issue because
It is, maybe
I
it
don't
is.
think that he legitimately should have free counsel in this case. He should have shown that he was indigent. The first case he said he needed free counsel, and Judge Moss said, okay, he was making $85,000 a year at that point. So there's an issue. I agree, Nevada's expending, resources and things like that. He's getting free resources. In terms of the court's time, in termination, yeah, the children aren't residents of Nevada anymore. Mom's not a resident technically anymore either. But I think Dad is, and I don't know if that matters to the court since it's his parental rights or not.
If I'm
You can, Miss Fuji.
Thank you. Just briefly, I'm with you, Judge. Don't think I didn't call Mr. Fleeman and go, he's going to get a free lawyer specialized in 432 or 128, NRS 128. And, I'm going to, get an expert retained for reunification therapy. I said, you don't need, if you go forward, if you allow this case to proceed in Oregon, in custody, which it truly is, then he will have to hire his own counsel or not be able to afford his own counsel. He won't have a free attorney, and he can try and get back into his children's lives. The termination is just a yes or no question for this, but he's getting an overwhelming amount of defense at Nevada's expense. It is unnecessary. I can tell you, I deposed Ms. Ruiz. Unrealistic expectations of a termination of parental rights case. So what ends up happening at the end is his rights are, my assumption would be his rights aren't terminated. That's it. Then he is going to be forced to refile a custody matter. And is Nevada equipped to hear that? No. So ultimately, it should be somewhere else. I agree with you wholeheartedly. I believe why they want to keep it here is because Ms. Ruiz was in the legal community, has ties to other legal professions here. I believe he ran for an elected position here in Nevada. There's a lot of unnecessary, just media and that's unnecessary to whether or not his rights should be terminated. Yeah. So when you look at a termination case, I don't understand why they chose this route. I think their expectation was they would serve and it would go away and she'd win by default. But unfortunately, in Nevada, it's such a severe punishment to terminate someone's parental rights. Right. So that was my 2 cents.
Here's where we're at. I'm gonna deny the motion for summary judgment. I agree that I'm not sure that it's relevant, but there is at least a disputed issue as to his residence. But the court acknowledges that there was no dispute at the time that the petition to terminate parental rights was filed, that the defendant acknowledged that he was a resident of Clark County, and so the court has jurisdiction to move forward with the petition. The issue on the inconvenient form, the court's not making any ruling today. That'll be, we'll see how that issue develops as the time. I mean, it's not a requirement that there be an Oregon proceeding, but it may, if there is an Oregon proceeding and it does sort of gear up, then it may seem like it may factor into that analysis. But that issue, it seemed like the issue was a little more better briefed back in May, but then it never sort of got addressed by Judge Moss. The issue before me today really isn't the inconvenient form argument. To me, today was just the motion for summary judgment, and I think that there's an acknowledgement even today by plaintiff's counsel there is kind of a disputed issue as to residence to the extent that factors into it, but I'm certainly not. I'm certainly making a finding that we have jurisdiction and we're moving forward with the case. All right. Anything else that you think we need to address today?
Just if we do orders, Judge, I just want to make sure that I don't know if the court, if we can have the minutes suffice on the denial of the motion for summary judgment, because it'll most likely be utilized for the Oregon proceedings. So if we say Nevada has continuing jurisdiction, the motion for summary judgment was denied, but the court's not making any ruling on the form nonconvenience or on the simultaneous proceedings, that at least leaves the opportunity for the parties to brief further the need
Yeah,
or necessity
Mr.
should
Fleeman-
arise for a UCC JEA conference.
That's fine. Mr. Fleeman, I'll let you prepare the order. If the two of you can agree on language, great. If not, submit orders and I'll take a look and make the decision. All right, otherwise I'll see you guys in January 9th.
Just for clarification, I believe there was a counter, well, it might not have been a counter motion, it was another reply, I think they requested fees. So I wanted to make sure that we addressed the issue at least today.
I'm sorry, I didn't hear that.
You had requested.
Did you request attorney's fees?
I did. I was irritated. I had to file. I am court appointed. I get paid either way. I'll withdraw that request at this time.
All right.
And just for the record, she didn't have to file. I said we could just bring it up at this hearing because it was already said.
That's
and
all
then
right.
I got a motion to.
That's all right.
So.
The request for fees is withdrawn. All right, thanks everyone for your appearances.
Thank you.